Good afternoon, Teena ma'am.
Hi, good afternoon. Hi.
Just
Just one
waiting
request.
for yes.
Please don't refer to me as ma'am. It feels really weird, honestly. Just refer to me by my name, if that's okay.
We used to call ma'am or sir to everyone on this platform. Actually, there's no difference. So
Okay.
just waiting for a few minutes to join others.
Okay. Oh, how many people are we gonna have? Just rough idea.
Right now, three.
Okay.
Start करते हैं टीना मैम with you. Eventually, Dhanya ma'am is just coming. She messaged me.
All right.
Ma'am, is it possible for the Viva to be on camera?
Yeah, of course, of course. I'm so sorry. I did not realize that I did not turn on my camera. Yeah. Perfect.
Anything you want to ask before session? Before Viva?
Uh, well, I don't have anything to ask, but my memory is a little rustic on a few topics. Just to put it out there, I might have to revise a little.
Okay, no guys.
Yeah,
Okay, can you introduce yourself?
sure. Hi, my name is Teena Dutta. I did my graduation from UPES with a degree in BSc LLB with a specialization in IPR. It's an integrated course. And right after that, so I graduated in 2023. And right after that, I have done a few internships. Uh, and I have a total of approximately 2.5 years of experience within the field of IP.
IP.
Correct, yes.
What motivated you to be in IP? You mentioned you graduated with the integrated course of BSc plus LLB. Seems so like you were planned to have this course already.
Yes. Well, primarily when I was in my 1+2, one has to decide as to which course you would want to pursue. One deciding factor was that I did not want to move forward with a conventional course as such. And eventually, when I started studying law alongside my BSc, it did give me actually a clearer picture as to where IP as a landscape stands in India, and I, as an individual, how I can facilitate in reducing the gap between what is now and how better it can be tomorrow by application of certain IPs. Um, with that, I did some internships, and that also gave me a much broader, in fact a more nuanced idea of the fact that patents is something where my interest would fit the best, considering I come from a science background, and I've always appreciated the amalgamation of the two, that being the science and the law.
So let's start with a simple question. What is IP? What is intellectual property?
Intellectual property, so I'll just break the terms to simply define it. First being intellect. Now intellectual is something that comes from our brain, something that we use, something we create out of our intellect, our knowledge. Property again can be a tangible form or in an intangible form. So any property that is made out of a person's intellect will will be called an intellectual property, and over that, once we seek a right, is when it is called an intellectual property right.
What are different types of IPs?
Um, the most prominent ones are patent, of course, trademarks, copyrights. Besides these, we do have design, we have geographical indication, traditional knowledge, semiconductors, there's plant variety act, then we have, yeah, I think that's about it.
What was your topic in BSc?
So my focus was more on the chemistry segment. But we did study a little bit of biotech, but the major focus was on chemistry and pharma.
So, what is 3D?
So 3D, it is divided into three limbs primarily. First being new form of a known substance. Now, the known substance is subsequently described in the explanation part, which, so the new form of the known substance, which does not result in an enhancement of its efficacy of the known substance. The third limb talks about the new use of the known substance. And the third limb refers to a known process which does not result in a new reactant per se.
What is therapeutic efficacy? How do you justify therapeutic efficacy in a compound?
So, first thing that one has to look at, the compound or the composition that we're referring to has any pharmaceutical or any curative effect, let's say, by by the very term therapeutic. So that is when you actually interpret the term efficacy within section 3D as therapeutic efficacy, because let's say I'm making a tablet that will cure a headache alongside a body ache, right? So it has certain therapeutic effect to it. When I say therapeutic effect, it is also important that the complete specification does specify that their composition has a therapeutic effect as such.
So, let me take an example.
Hmm.
There is a compound which is already existing in this public domain,
Hmm.
but I have done a certain modification in the structure of that compound, and now the compound is highly thermal stable.
Okay, thermally stable.
Uh,
Okay. Hmm.
let's say that the earlier compound was able to withstand up to a temperature of 12 to 15 degree, but now it can withstand to a temperature of at least 40 to 45 degrees centigrade.
Hmm.
So can I consider it as a therapeutic efficacy?
Mm, well, unless it actually backs up with a therapeutic effect. I mean, simply saying, uh, there's a thermal stability or there's bioavailability will not suffice. We need to show a therapeutic efficacy data against it. That simply saying that, the temperature, the effect of the temperature is better, or, maybe the medicine is getting dissolved quicker, and that's why it's giving, a better effect. It won't suffice to say that, at least as far as the judgments that have come across say that.
Mm. Under what conditions publication is prohibited?
um, there are three scenarios. First being if I have filed a provisional and is not accompanied with a complete spec. Second being if I have withdrawn my application within the 15th month before it being published, of course. Third being if there is a secrecy direction imposed over an application.
What is opposition?
Um, Simply put, there will be, if it's a pre-grant, then an interested person uh, will basically oppose your matter from getting granted. Same goes for post grant as well.
What you are exactly opposing is?
The grant of the application, of course.
How can you add an applicant after filing an application in an application?
How can I add an applicant? By way of Form 16. I mean, that's how you file an assignment. Uh, yeah, Form 16.
Okay. Let's take a situation
Okay.
where you file an application,
Hmm.
and from the date you file the application for the patent, regard to that date, when the fourth year comes, your patent is granted in the fourth year.
Okay.
So by when you have to file or pay your first renewal fee?
Uh, I'm not very certain on the timeline, but I'm certain of the fact that there's an accumulated fee that you have to pay for the initial first till the third year. I think you get about 6 months timeline. I'm sorry, I'm not certain on the timeline there, but again, renewal fees are paid on an annual basis. Uh, I'm sorry, I'm not certain on. I think it's renewal.
If you don't pay the renewal fee, what happens to the patent?
It gets lapsed.
And if you want to realive your patent, what is the procedure?
One has to file for restoration.
Hmm. Up to when you can file the restoration?
18 months from the date that it has ceased to have effect.
What are the grounds
Grounds for sir? I did not
for
understand.
restoration? On what
Rest-
basis you can restore your application?
Um, one being that the failure was on an undue.
What
It
is
is
the difference between patent of addition and amendment?
so patent of addition simply means that if I have an improvement of my application, so I would have a parallel application that would go alongside my parent. As far as amendments is concerned, which is governed by 57 to 59, that deals with certain amendments that you make within the scope of what has been disclosed.
What is the difference?
uh, Difference is that pattern of addition in pattern of addition you are adding something new, that is the
Mhm.
improvement of that already exists. But when I'm amending, that has to be within the scope of what has already been disclosed. You cannot go beyond that.
See, if you want to amend the name or the address of a patentee in patent register,
Of a patentee. Okay.
then how will you proceed? Which form will you prescribe to him?
uh, Again, I'm not very certain, but I believe it should be form 30. uh, you said change in the name of the inventor, right?
Patentee.
Patentee. Change in the name of a patentee, as in
Not change.
hmm.
There is an amendment.
Maybe we've added some surname is different in
Like
some.
you used to write Teena.
Right.
Because of the certain mistake, you mentioned TINA. Now you want to amend.
Yeah.
You're not changing NM, you're just
Form
amending.
Form 30. Form 30.
In how many months a patent get published?
18 months.
And if you want to publish it early,
We file a Form 9 for that.
okay. So how person should decide whether to go with the early publication or the publication after 18 months? On what basis he should
Uh,
decide?
the best scenario could be one that I have identified that there is an infringing act happening against my patent, so I would want in the entire process to get expedited. That being one, because the damages are counted from the day that the publication happens. Second scenario being, let's say, um, I cannot think of any. Yeah, I think that's it. That's it. That's all I can think of. Hmm.
So, being a female candidate, can you
Right.
identify certain special provisions provided to female candidates, applicants, female applicants in patent?
Yes, I mean, we are entitled to file an expedited examination.
Mhm. What is it?
I'm sorry, as in, okay, so we have to file a Form 18A in that context.
So, if you have filed an application as a female applicant
Mm-hmm.
and the FER is issued to you,
Okay.
and you have compliance all the objections raised in the FER,
Okay.
then after that, in how many months the controller is bound to provide you the grant?
Uh, this is in a scenario of an expedited
Hmm.
case, right? Okay.
Only he is bound in expedited and not in the other.
Yes, yes. I think it should be 3 months. Uh, yeah, 3 months.
What is compulsory license?
Um, so there are certain grounds for. So compulsory license would, in its basic sense, mean that it is a kind of license that one would seek, especially when, let's say, in case of pharmaceutical drugs, for example, because that's like the only CL that we have had so far. If the patent is not being worked or is not available at a reasonable price, or even after importing it is not sufficing the requirement of what is required within the jurisdiction of India. Yeah, that's it.
Have you seen any application, patent application, how the complete specification and the forms are drafted?
Yes, a few, yes.
Okay. So what are the basic information that we need to provide in complete specification,
The basic information.
or the how the complete specification is to be drafted?
Um, so we start with a Form 2, I mean, the general Form 2 template that we have, wherein you have to first disclose whether or not it's a provisional or a complete to start with. Then it will have a title, the applicant name, nationality, and their address. Then it will be accompanied with a preamble. Now, the preamble basis the kind of application that you're filing, it'll vary. Then moving ahead um, with the specifics of the specification as such. Um, it starts with, oh, I'm sorry, I also missed the title that needs to go in the form too. Again, coming to the specification, uh, I'm sorry, I cannot recollect what it starts with. It's the field of invention. Then we go on about with the summary, then the summary of the drawings, then the detailed description.
If any biological material is involved in your invention or
Okay.
in your complete specification,
Okay.
then under is there any separate permission that you need to grab?
Uh, I think we have to take permission from the Central Biodiversity Board, by filing an NBA application that I'm using XYZ biological material in my application, and the source of it, especially, more importantly, if it is from India, that biological resource.
So is it necessary to disclose the source? See,
Uh,
if my microorganism is not novel, then still do I have to disclose the source or the origin of that material?
See, as far as the requirement is concerned, I think as a matter of prudence, one must, because from from my studies, I remember the Biodiversity Act was introduced primarily to safeguard, misappropriation of certain substances and not being returned back as an incentive to the community. Because a lot of times we do not realize, and we use a lot of things just under the light ki हाँ ये तो available है, but the source is never acknowledged.
So in the last, just a very easy question.
Sure.
What is patentability criteria?
uh, we do have a three-prong test, but from what I understand, one has to meet the 21J requirement, that is of novelty, because only then you will move on to the inventive step or the industrial applicability. So the primary requirement is of novelty.
What is design?
Uh, Design, uh, in basic terms, I'm sorry, I may not be able to quote the very language of the act. I apologize for that.
No worries, no worries. Explain in
Uh,
your terms.
sure. But let's say if I have, a particular a design in a particular kind of an orientation, which has lines or figures or colors, which is aesthetically pleasing to the eye. That is something that I'll call a design. That is again applied on an article.
What is not design?
What is not design? First and foremost, again, has to be novelty. So if it is not novel, it cannot be a design. Second, with novelty comes the factor of anticipation, like we've seen in patents as well, that if it falls within the public domain, again, will not qualify. Thirdly, if it has certain scandalous material or obscene material. Lastly, there are certain IPs that are restricted, in particular, like trademarks. If your design encompasses trademark or a copyright, uh, then I think there's some reference to merchandise, if I'm not wrong. Yeah, that's about it.
Any particular sections of Patent Act which are directly enforced in Design Act?
Uh, I'm not very certain which sections, but if I logically see, I mean, if I put both the acts parallelly, then I think it'll be the rights of the controller who are examining the application. And uh, in fact,
Have you
in
read the
scenarios,
Riyadh Design Law Treaty?
yes, I have. Yes.
Then what is the impact of that on the definition of design and article?
Mm, I don't think there has been I'm not certain, but there's no change in the definition of designs. Although the GUIs have been added, and there are other things as well, of course. But as far as the definition of designs is concerned, I'm not sure if there's been a change.
Now, let's get out of the interview mode.
Sure.
Although you are well prepared, I would rather say,
Thank you.
because whatever you tried to answer was mostly correct. Although they were the like the hit in the dark room, but they were mostly correct. But just because you were lacking the confidence,
Okay.
they might deduct marks.
Okay.
And one thing that I liked about you is when you don't have any clue, you simply said, "Sir, I don't know." That's
Hmm.
good part. Don't try to answer each and every part.
Okay.
If they
Okay.
are asking 10 questions, कि मतलब पांच तो मना कर रखे ही आओ, है ना, कि पांच के सॉरी, दो क्वेश्चन तो आप बोल दो कि नहीं पता, ज्यादा दिमाग मत लगाओ. Because
Hmm.
when we try to present our knowledge that we know everything,
Hmm. Hmm.
they will try to drag you down. That will happen,
Okay.
है ना.
Now, like we discussed it yesterday, what kind of impact would it have post? Because my interview is scheduled in the second half. All even though I'm the first one in that lot, right after lunch, मतलब सबसे पहला number ही मेरा है.
They will be on ease.
So what should I expect?
Easy questions
Are you
and
sure?
direct questions.
Okay.
But one thing that you need to keep in mind
Hmm.
and on hold is your
Okay.
hand movements.
Right. Okay. Okay.
Those
I,
will provoke the panels. Definitely, these is going to provoke them.
okay. Fine. Fine.
Now,
No,
have you saw any in mock interview videos of IES on the YouTube?
no, I have not. I have
Go
not.
through those. Observe the sitting posture of those candidates.
Sure. I'll do that.
You only the body part that is going to be moved when you are sitting there is your lips
Okay.
while
Okay.
speaking.
Okay. Okay.
Not even too much your head, definitely
Mhm.
not the hands,
Okay.
and a little bit smile.
All right.
If
Okay.
you are moving your body and too much na, they
Hmm.
will definitely understand कि इसको तो थोड़ा सा समझाना पड़ेगा.
I
ऐसा
see.
हो जाएगा.
Acha. Okay.
थोड़ा
Okay.
सा उसको कंट्रोल कीजिएगा.
Right.
बाकी आपका प्रिपरेशन बाय द एक्ट, बाय द नॉलेज एंड योर रीजनेबल रीजनिंग, बट लॉजिकल रीजनिंग इज गुड.
Okay. Thank you.
You just need to keep on revising, and let us discuss the question in which you need to understand. Intellectual property, it is of intangible form. Okay, and therapeutic efficacy in the last, and
Hmm.
the word you use, data,
Right.
that saved you. Therapeutic efficacy is only justified on the basis of clinical trial data, the data collected in clinical trials.
I'm.
Even
Hmm. I'm sorry.
controller ask for that.
Just a concern. In fact, quite recently, I was having a discussion with an attorney on the same lines again. The clinical data fact. There are a lot of inventions that when the R&D is happening. Generally, it starts with something on a mice, right, and then it moves on to the clinical trial. So, what if my matter is still at a stage that it has not reached the clinical trial
Then you
process?
cannot justify your therapeutic efficacy. You
But then
have
I
not
would have
completed
the
your
efficacy
invention.
data, right?
Even when some in some of the cases, controller directly asks, "Show me your data, clinical trials data." So on the basis of only clinical trial data, you can justify your therapeutic efficacy. There is no other way.
All right.
Uh, Trials on the mice or the guinea pig is not clinical trials. Trials on the humans is clinical trials.
Hmm. Right.
And the grounds of restoration
Hmm.
was up to the mark, but you mentioned the timeline you need to go through. When the patent is granted after 2 years of application, na,
Hmm.
within 3 months of the grant, you have to pay your first final fee, renewal fee.
I didn't quite catch that. I'm sorry.
Even the
Hmm.
patent is granted after 2 years of application,
Okay. Okay.
then the first renewal fee that need to be paid is
Hmm.
in within 3 months of grant.
Okay. Okay. Fine.
And
Uh, Grant,
to
or would it be? Because I remember reading that there is a difference in the dates. One being of the recordal, and that being of when the certificate is issued. So,
no certificate
sorry,
issued,
the intimation of the grant.
there are two dates, date of grant and the
Hmm.
date of recordal.
Recordal. Yeah, exactly.
uh, Generally most of the cases these both dates are same.
Okay. Okay.
Mm. So you can say that from the date of grant, but exactly to be
Hmm.
said, to be precise, it will be date of recordal.
Recordal. Hmm.
If there is any pre-grant opposition going on, na,
Okay.
then there is a chance these two dates could differ.
Okay. 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 Also, I just wanted to ask another thing. So I'm not very well versed with the fees as such. I mean, I've not
Not
ratified
to
them.
worry, not to worry
So
about
I
that.
hope that won't really impact.
Not to worry. Because the way you are answering is good. Don't worry about the fee.
Okay, fine.
What is your score in paper one? 61, right?
67.
67.
Yeah,
So you need to prepare with the 33. हो जाएगा, कोई problem नहीं. I think you will be qualifying this the examination this time itself.
thank you. Thank you.
है ना? हाँ.
Yes,
I think you have a little bit problem in design.
I agree. I think I'll have, like I said, even before starting the interview, I'm a little rustic on that part. Although
Hmm.
I'm quite hands on with the Riyadh law. Uh,
But still,
hmm,
you didn't understand the Riyadh law.
huh,
Riyadh law was having direct impact on the definition of article and design
okay,
because of the GUI introduction in this proposal of treaty.
right.
Now, design is something that could be of virtual design. But before, virtual design was not considered in the Design Act. So that is
Hmm.
the impact. Now the definition of design will be changed.
Hmm.
Now the physical form plus non-physical form of article is also to be considered. Because
Okay.
virtual designs, earlier articles were only a physical form.
Right.
But you
Um,
cannot implement virtual design on physical form. No? So there
okay.
has to be an article which is also of virtual, that is non-physical form.
Uh, Another question, just to follow up. There were two more introductions. Now, if I were to be posed a question on, one being that multiple designs in single application, second
Hmm.
being the division of application.
Hmm.
So, I just want to get a clearer understanding on the fact that you're saying that I can file under the same class, I can file multiple designs. Is
Yeah,
that?
with a little
But
bit variation.
if I look at it from a divisional perspective, like we do in the patents, how am I to interpret that?
See, when multiple designs are filed, there has to be a little bit invariant. It doesn't seem to be
Can
two
you give me an
different
example?
designs. A
Can you give me an example?
little variants
Hmm.
like you have a Mickey Mouse.
Okay.
You have filed a Mickey Mouse in two different colors. One is black, and the another is a combination of red and black.
Okay.
Okay, so these are two different designs with the
Hmm.
almost similarity with a little bit invariant in same class. But you cannot find that design of Mickey Mouse and a Donald Duck together because these are two different designs.
Hmm.
And if so happens, because you are just an applicant, you don't know what is the difference according to the law. So if you find two different design in a single application by mistake, controller has a privilege to divide those applications under divisional application.
The controller has, we don't.
No, listen. Till now, it is
No.
not cleared who can file the divisional. These are
Okay.
the proposals. Now the draft
I
of
understand.
act has still to be drafted. So we
Mm-hmm.
need to wait. So till then, we will giving the privilege to controller to divide our application. Not we are taking the privilege.
Not me. Okay.
Ah.
Okay. Um, One last question. Um, uh, so when uh, the part where it talks about the 50 article requirement, which is already there. I mean, I did not really understand the purpose of introducing.
There is a actually there is an interface between Copyright Act and the Design Act.
That I know, but what did it mean by saying that if it ceases to have effect, then the copyright should sorry, the design right? I don't know. I just couldn't make head tail of
See,
what they're trying to say.
earlier it is
Hmm.
now like if
Hmm.
a design is registered in Copyright Act, then if you made more than 50 articles of that particular design,
Hmm. The
your
51st.
copyright will cease to have effect
Yes,
and the design will come in public domain as well.
correct.
Okay.
Hmm.
Now there was a conflict between this concept and the real philosophy behind the copyright. Uh, can you tell me whether I need to file copyright to have a copyright?
No, it's not a cynic one on, but yes, for design it is.
Hmm. Copyright is the only IP which is by default given to the author.
Yes. Hmm.
So there was a conflict between that if design is by default considered under copyright and I'm not filing any application under design or copyright,
Okay.
whether still I will be having my copyright?
Uh, yes.
Na? But earlier it was contradicting with this philosophy of Copyright Act. Because if I am not filing the design in
Uh,
copyright and I have made the 51 article of the design, the copyright
mhm.
will have ceased to have effect
Correct.
and my design will be in public domain.
Right.
है ना? So to remove this contradiction, they have removed the provision of 50 articles. But to align this provision with the Design Act, they have said, they have proposed that the copyright without filing under Copyright Act will
Hmm.
be given for only 15 years. Because otherwise, copyright has a right term of 90 years after the death of author.
Right.
But in case of design under section 15 of copyright, by default, the copyright will be given for 15 years only.
Hmm.
That is why.
Okay. I think I'll go back on. Yes. I think that's it from my side. Thank you.
And although there are 10 proposals actually, then 10
Hmm.
amendments are proposed in Riyadh Treaty.
Right.
One is of deferred
I
publication.
actually have it on me right now. That's why I was actually brushing it up right before because honestly, I was a little, uh, I don't know, a little confused about a few factors.
Not to worry.
Yeah. Again, the statutory damages, I'm not very confident on.
Just keep on studying. If you have any doubt, just ping me up.
Sure, sure,
So
sure.
right now, I would like to move to Dhanya ma'am.
Of course. Thank you so much. Thank you.
Oh,
Okay, yeah. Good morning, Rajat. Good morning, all. So it's good afternoon, I think, right? We are already 12:40. Yes, I'll just join my video. So
can
yes,
you?
I'm not fully prepared as well, but then yeah,
Oh,
definitely.
nobody is, ma'am. Till the Viva, nobody is fully prepared.
Yeah.
Nobody feels confident.
Okay.
So anything you want to ask before we start?
Nothing specific. We'll go ahead.
Let's start with an introduction.
Okay. So, good afternoon, sirs. My name is Dr. Dhanya. I did my PhD in chemistry from BITS Pilani, and I have been working as an assistant professor for over 8 years. And my teaching career started as a PGT chemistry after qualifying MSc B.Ed, and then I moved to higher education. So my last job has been with the Bangalore City University as so I've been taking classes for PG, and I did my PGD IPR, as well as I have been taking a course in IPR, skill enhancement course for graduate students, UG students under Osmania University. During my doctoral research, we have filed a patent, it's under examination stage, and that's when I really wanted to explore more in the IP field, and that's how I have appeared for the exam this time. Thank you.
So you told you are into teaching.
Yes.
Why do you want to quit teaching?
Yes. So teaching for me has been a very fulfilling career, and I really love the job. So I think where as a teacher and a researcher, what I've found is there is a gap between the laboratory research and the innovation field in the industry. So we stand as a bridge between these two arenas. So definitely a better knowledge of IP would give me an edge when if I have to shift to academy from academia to industry, as well as if I have to start my own lab and a research in a research institute or in a university with my PhD students. It gives me an authority and to talk about innovation protection, and I can contribute in that way to the innovative ecosystem of the country.
Okay. So, Dr. Dhanya, can you explain what is synergy effect?
Yes. See, you have two components there which work hand in hand and enhance the efficiency. Like in the case of drugs, for example. So you have drug A and B. So A has one medical effect, but when combined with the B, you get a synergic advancement over the medical effect. So, for example, say paracetamol. So, paracetamol is actually it reduces the temperature, but then it can also relieve pain to some extent. So that has these are two synergistic effects of the same drug.
So, is it patentable?
This is explained under the 3E, section 3E. So a mere admixture will not be patentable, but then an enhanced synergistic effect, which is supported by data, could be patentable.
You just mentioned supported by data. Which kind of data?
Clinical data in case of a drug, and in case of in case of a product in the industry, say for example a paint or emulsion or anything of that sort, then its action could be assessed. So there should be a standard method wherein you evaluate how the synergistic effect is actually working.
So, have you filed any patent in now? As you mentioned, you are already a PhD
Yes,
holder.
I have, and it is under examination right now.
Okay. So, what type of claims you use to file your application?
So in my application as such, we have given independent and dependent claims related to the innovation, and we have both process and product claims included.
What is anticipation?
Anticipation is anticipating any prior publication in form of any document or a patent or a specification or a claim which could actually be spoiling, or which could actually be taking away your priority of your application as per the sections 13 of the act.
What is prior art?
Prior art is a prior published document which is available in India or abroad, or and these documents could include a prior patent which is published, or it could include a prior publication which is in the public domain, or it could also be a part of the specification or any other publication which is available to the public. So, in terms of the invention that is claimed. And prior arts are given specifically the types of prior arts in the section. So under anticipation, they are mentioned
What are
in section
types of
13.
prior art?
Types of prior art specifically, I'm not so sure if they're classified as such, but then I feel these are publications, um, patents, and then research articles, etc.
So you learned about anticipation. Let me take an example. There is an application filed in India by you,
Yes.
and a person in US
Yes.
has filed the same application earlier than you,
Okay.
but got published after your filing date. And a third person filed the same application with the same invention earlier than you in India and haven't got published yet.
Okay.
Then out of which of the applications will anticipate your application?
The Indian application would probably anticipate my patent application because patent rights are territorial as well. So I think it will be the Indian application because it is filed prior to and it's a secret prior art because it is not yet published, but it is uh, filed prior to my application, is what I understand.
See, if there is you got a FER on your application, and one of the compliance of the objection that raised by the controller in FER is not, you are not able to compliance that, you are not able to remove that objection. What action could a controller can take on your application?
The controller may refuse to give sanction to the application or to proceed further, but he can also give a chance for amendments. So the application could be amended according to sections 15(7) to 59. So that could be the scenario.
The, uh, as per your opinion, you think that the whatever the decision controller has taken
Mm.
is not appropriate, and you have some evidences to prove that.
Okay.
Now you want to challenge, or you want to, desire to be heard again.
Mm.
What is the procedure?
In terms of the application, like whatever decision he has taken. Okay, so we can go for appealing. We can appeal to the High Court or the IPD against the controller's decision, or we can request in Form 24 by filing Form 24 for reviewing the controller's decision on the application. Uh, we can request for a hearing as well, so we get a chance to present our case in front of the controller.
Who can file an examination request?
The applicant, the inventor, or any assignee or a legal representative of the applicant, all of them can file an request for examination.
If you don't file an request for examination, what will happen to your application?
The application will be deemed to be withdrawn or abandoned. For I think that's the right term, because you are not unless a request for examination is given, there is no examination done as per Indian patent system.
If you want to withdraw the application, is there any refund process also?
If the withdrawal is done within 15 months before publication is done, then 90% of the amount, if at all you have given the request for examination and you have paid the fee, that amount could be refunded. But for that, you have to file the Form 29.
So that means you want to say that if I withdraw my application after 15 months, there will be no refund.
No, there is a refund. That's what I'm telling. 90% of the money could be refunded. if you have requested for examination, so that money could be refunded.
See, as taken a situation that you and one of your friend was working on an invention in the lab,
Okay.
and few months later you came to know that the person who your friend who was working along with you filed a independent application of the invention on which you both were working together.
Okay.
So you felt betrayed. Then you want your invention back.
Yes.
How will you proceed? And the invention is already been granted to him.
Okay, the patent is granted to the other person. Okay, so in this scenario, either you can definitely file for revocation, or you can file Form 14 for opposing the decision of grant of the patent. And you can also request and to consider under Section 28 to add as an inventor. So you can, since this is obtained under false means, so you can under 26, Section 26, your name could be added as an inventor. 26(1), the patent can be amended, and you can be added as an inventor as well. So you can file a suit against it.
So under Section 26, you will be added as an inventor.
Under Section 26, if it is obtained in fraud, there is a provision that you file Form 12, and the patent is granted in your name.
But to grab the provision or to have the benefit of Section 26,
Yes.
under
Oh,
which
that you
process
have
you
to
have to
do
go
post
through?
grant opposition. So after this will be done after the post grant opposition, because you said it is granted, we can file for a post grant opposition,
And if the patent is not granted,
a pre grant opposition.
then how will you proceed?
In a pre grant opposition. Okay, so in a pre-grant opposition, you have to. It's done after publication of the patent application, and you have to pay a fee of 4,000 rupees as a natural person for pre-grant opposition, and then there'll be a hearing done from the other party as well, and the controller will finally decide on the hearing.
How will you get your invention back?
After the pre-grant opposition also, you can there will be the other patent, the inventor could be removed, and the name of the inventor, if it is the same invention, yet since you want to add yourself as an inventor
No, no,
according to.
not inventor, not inventor.
Yes.
He is an applicant and you want that invention to be in your name as an applicant.
Okay, so I am the applicant and I want to get it back from the other person. Is that so?
Yes.
Okay, so I have to, after the pre-grant opposition process, the controller will decide on who will actually be getting the rights. So then you
He
can
has
ask an
decided,
applicant.
he has decided that it belongs to you.
Okay, so I have to file Form 6 to add my name as the applicant in the application. I think that's what.
Where it is mentioned, Form 6 has to be filed.
I didn't get you. Sorry.
How did you conclude that Form
Oh,
6 has to be filed? Because
I'm sorry. I'm
it's not
sorry. I
mentioned
think
anywhere.
It's not Form 6. I have to go with Form 13 as for amendments. I'm a little confused here. I'm sorry.
What is secrecy?
Secrecy directions are explained under Section 35 of the Act, wherein the invention that you are seeking protection for is violating or is in violation of the defense purposes of the country or national security. So government can interfere and can either revoke or prohibit you from, ask the controller to further process application.
Okay. What is FFL?
Foreign filing license, which is defined under Section 39 of the Act, wherein an Indian resident is supposed to be getting a foreign filing license or permission from the controller prior to filing in countries abroad for a patent protection. And this could be done 6 weeks, like if you are filing in India, then 6 weeks prior to the filing, that protection has to be sought. And the controller will decide mostly in 21 days from the receival of that such an application. And it is filed using Form 25.
Can you amend the priority date of a claim?
Amending the priority date of a claim, like you can request for post dating of an application. A priority date of a claim could be amended as well, I think, by requesting to the controller by
You
in
can
case
amend the priority date of claim.
amending in the sense like if you want to post date an application, then
No,
post
no,
dating.
no. I'm not asking about post dating. I'm asking about amendment of priority date.
No, I think that's not allowed.
What is not allowed as per the amendment? What you cannot do with the amendment?
Okay. So amendment could only be in terms of declaration or correction, or no new element should be added in which is not previously disclosed in the specification or in the claims.
What is the difference between amendment and the rectification?
So amendment is always about making some changes in your specification or claims, which will not, or which will not in such a way that it will not affect the originality of the idea or your original representation of your invention. But a rectification could be a clerical error rectification or any other rectification in terms of the figures or any other rectification which is not totally changing the nature of the claims or nature of the invention description.
But we don't rectify the specification, we rectify the register.
Yeah, okay. Rectification will be for mostly for clerical errors, is what I think.
Okay.
And then also for the names, address, any change there within the
Then what is the difference between section errors in change in clerical error under section 78 and the rectification? If rectification is clerical error,
Okay,
what
right.
is the section 78 is defining?
Okay, rectification. I think I'm missing something here, but rectification is it related to controller's power, controller rectifying? I'm not sure. I'm sorry.
What is the discretionary power of controller?
Controller has some of the powers of the civil court, like he can call for summon the person for any clarification, and then he can ask for documents, evidences, and hearing can be done, and then controller's decision is final in terms of the procedural part of the patent specification, patent application for that matter. And
Now,
controller has the right to extend the timelines.
okay. See, controller have call you for an hearing,
Okay.
and you think that you won't be able to present in the hearing, you want to adjourn the hearing.
Okay.
So by how much time you can adjourn your hearing, and up to when you have to inform the controller?
I'm not very sure of this timeline, but as far as I remember, it's 10 days. Within 10 days, you have to appear for the hearing. And the adjournment, I think it's 2 months. And what I know is it's only twice that you can do that. Like you cannot do it more than 2 times, that adjournment.
Do you know Form 27? What is it? What is the importance of that Form 27? Let me take an example that you are a patentee
Yes.
and you have issued an exclusive license of your patent and two general licenses.
Okay.
So total four people are involved in your patent. First itself you, another is exclusive licensee, and the two other general licenses. Now, out of these four, who is bound to file Form 27?
All, according to the Act, all are supposed to file Form 27 for showing, for informing the working of the invention. As and but it can be filed together as well. So
So
in
to
one
be
single
together,
form is enough for filing the working of invention.
so to file that together of Form 27, what is the criteria?
It should be related to the same invention. So if you're saying like it is different rights given, and you now, as of now, you only have one part of the right, uh, then I need clarification. I have to check that.
We will have a discussion then.
Yeah. Okay.
If you don't file Form 27, and I like now I am at your place
Okay.
as a patentee and I didn't file the Form 27, and it's been more than 5 years, and you as a competitor came to know about that and you want to file a complaint, how will you proceed?
Form 27. You can file for revocation of the patent because it is non-working under 64.
What is design?
A design is a feature applied to any article which could be in the form of an ornament, shape, configuration, or pattern of lines, composition of pattern of lines, wherein it gives an aesthetic appearance, enhanced aesthetic appearance, and does not really contribute to any functionality. And it's not, and where we don't, when we check the protective nature of a design, we don't go for the method of production of that design, the mechanical or chemical aspect of the mode of production.
What act will be considered as, what action will be considered as piracy?
In the case of design act, yes. So for it, if the design is copied on any other article without a prior permission, then it could lead to piracy of the design, which belongs to the same, either the same class or any other class of the act. Or even when you publish that, or make use of it. So
What are the sections of Patent Act which are directly enforced in Design Act?
okay, to start with, patents, of course, only the terminology differs in some cases. Like, for example, for a patent to be valid, it has to be novel, whereas for a design, we say it has to be new or original. So the concept is the same. And then when it comes to anticipation, or then again, when we talk about prior publication, so in Designs and Patents Act, prior publication will lead to destruction of novelty. And then again, controllers powers with respect to this, and then revocation, again, both could be put to revocation, and or the term is different, cancellation is used there. And then
What is the term of design?
term of design is 10 years originally, and it can be extendable up to 5 years by filing form 3.
And if you don't file Form 3?
It will be lapsed, the design protection will be taken.
And if you want to restore your design?
You have to file form 4, I think. I'm not sure. But it has to be filed within 12 months.
So then if the controllers have decided to restore your design, what
Yes.
is the additional fee that you need to pay?
Need to pay 1,000 rupees for design.
And what is the additional fee in case of patent?
For restoration.
Hmm.
Okay. I'm not sure. I think it's 4,000. I don't know. I'm not sure of that. I'm sorry.
I think no, Viva is over. You know,
Thank you.
what is your score in paper one, ma'am?
61.
61. So you are seeking almost 41.
I need 39 or 40.
No, you are. I think you will be able to score 40.
Oh, thank you. If you think so. Good. My paper too, I think went fine. So I'm just relying on that also.
Ma'am, that will be
Yes,
privilege.
we
That will
don't
be
know.
like a bonus marks, but I
Mhm.
won't consider those until
Yes,
and unless we came to know what is
yes,
the actual score.
true. So
You know?
fee, of course, I have to revise totally because I'm not so sure.
Hmm.
Uh,
Now
and
let's move on to the questions that we asked. Although you answered very well, why do you want to be patent agent? Synergic effect, 3E mirrored mixture, independent, dependent. Ma'am, go through once what are the different types of claims.
like what I know is Jepson claims, Marcus claims, and
Omnibus claims, means plus
oh,
function claims, and
okay, okay.
there are several types because in particularly chemistry now,
Hmm.
Marcus claims and Jepson claims are the most used claims.
Oh, yes,
So they
yes.
might ask you what are the Marcus claim and the Jepson claims.
Okay, okay.
And anticipation is something which destroys your novelty.
Novelty. Okay, that term I didn't use.
Ah. If it, what is anticipation? Any document which destroys our novelty.
Okay,
Prior art is that document which is destroying our novelty.
okay.
So in regard to prior art, because you have already filed an application
Yes,
or a
yes,
patent, they might ask you what different databases are used to search for prior art.
yes, yes.
They could be public databases, they could be
Yeah,
paid databases as well.
yes.
है ना? Teena ma'am, have you gone through any databases till now for prior art search?
Uh, well, for the government ones, we of course have the IP India, Patent Scope, eSpaceNet. Then for USPTO, I think it's Patent Center. Sorry, Global Dossier. As for the paid ones, I've used PatSphere so far, and Orbit. I've heard, but I've never used Orbit. But yeah.
So these are the databases.
Okay. Yeah, in pass and all that, right?
INPAS, which is of India,
Yeah, and UK.
SpaceNet of European Patent Office, USPTO, Global Dossier, PatSphere. PatSphere is the one of the most used databases, and it's a paid one.
Okay.
Huh. When remember I asked you a question where two different applications were filed by two different applicants in
Ah,
one.
yes, yes.
Both application will not be able to anticipate you.
I didn't get you. What was the question?
You filed an application in India,
Hmm.
another
Ah,
applicant.
yes, US. This was there in that paper one also, I think, something
Hmm.
similar to this, and it was confusing.
So both application is not anticipating you.
Because ours is public, it's not published, right? I mean,
The other application which were filed in India was
Hmm.
not published.
Okay,
So until and unless it is published, it won't anticipate you.
okay.
But the application which was filed in US, although
Hmm.
it got published,
Hmm.
but that will not also anticipate you because that application is not filed in India.
Okay, but I still am not very clear on this. Like, because when we talk about anticipation, we are really talking about any document which is available in public domain, whether in India or abroad, no? No?
But in that case, see, there is a difference. But that publication of that particular document has to be before your filing date.
Okay, okay.
Although that application in US got published after your filing date. So
Okay.
it will not fall under category of previous publication.
Hmm.
Clause 1 of section 13.
Okay, publication was done after filing. Okay, I missed that point.
But it will also not fall in the category of prior claim as well, although it got published after your filing and the application was filed before your filing date. But in the clause of prior claiming, there is a certain condition that particular application has to be filed in India. Hello. Hello, ma'am. I don't know why, but it got crashed at the moment. Hello, ma'am. I don't know why the
Yeah,
Zoom got.
hello.
So let's continue.
Okay, I think it was a problem from my end. I don't know. It got disconnected from me.
No, actually, my Zoom got crashed.
Oh, okay, okay.
I don't know why it happened. So let's leave it. So the condition for
Okay.
the application to be prior claiming you in the case of anticipation, there is a condition that application has to be filed in India. Without filing in India, an application which is published after your filing date and has a filing date earlier than your filing date cannot anticipate it. So the application filed in US, although it has earlier application filing date and got published after your filing date, but if it is not filed in India, it will not anticipate it.
Okay.
There is a chance that he might enter India through PCT, through National Phase Entry.
Yes.
Then it will start anticipating you.
Okay. What about if it is already like see since they have a published prior, they will get a patent also possibly prior, right?
Definitely.
So if ours is still in the process of examination and if it is granted prior,
But the anticipation will be considered according
prior,
on the basis of publication.
prior to no publication.
Publication.
Okay.
So that is why if you go through a question in 2022, there was a question of Nile incorporation.
Yes, yes.
That was on the basis of previous publication, although
Okay.
it was having anticipation on the basis of prior claim.
Okay.
But if we go through the publication has to be done before your filing.
Okay.
That is the beauty of this patent act. And if you go through the section 33, that is the whole crux behind that.
Yeah, prior publication.
File a provisional, have secured your application filing date. After that, do whatever you want to do.
But then where do this secret prior art come in? Like, why do they talk about it?
Secret prior art is nothing but a secret use. It is a ground of revocation under 64.
Okay. It has nothing to do with the grant then. Okay.
Later on, a person can file a revocation suit on the ground of that ground, but
Okay.
it will not come into picture until the patent is granted.
Okay.
And although you mentioned properly that your application get refused or amended, but you mentioned that you will directly go to the High Court in under 117A.
First, I should go for appeal, right?
You
Yeah.
should appeal to the 77 under 77.
Okay. Okay. 77.
If you don't file the request for examination, your
Hmm.
application will be deemed to be withdrawn by default.
It's not abandoned, no?
No, not abandoned.
Okay. Wait, I really have a confusion sometimes. Like abandoned, withdrawn, then
Abandon is under only two conditions.
okay.
First one is if you don't file the complete specification followed with the provisional one.
12 months, yeah. Okay.
And another, if you don't reply to the FEL.
Okay. Then it is abandoned. Okay.
Although there is a separate condition as well under section 40, liability of contravention. If you filed an application in India, but you filed for an application without permission, in that condition as well, your Indian application can be abandoned by the patent office. So abandoned.
Then I thought is it not from our end, like the applicant's end?
It could be from anybody's end, but abandoned is when something you didn't follow the provisions.
Okay. Okay.
When you didn't follow the act or the provision of the act.
Okay. Okay.
But withdrawn is when you are not willing to follow the process or the application. You don't want the grant.
Okay.
That is why the only condition in which the withdrawn is by default when you don't file the request for examination.
Okay.
Otherwise, you have to file the form for withdrawal. Which form is filed?
29.
29. So you have to file form 29.
Yes.
The only condition under which it is by default withdrawal when you don't file the request for examination.
Okay. Is there any specific difference between abandoned and deemed to be abandoned? Because they asked that, right?
No, question should be like, what is the difference between deemed to be abandoned and deemed to have been abandoned?
Okay, okay. Deemed to have been.
That question was raised in 2025 or 2024?
Okay.
No, 2025.
Okay.
First, we thought it is just a grammar. Why they are asking about so much grammar? But
I think there is something.
there is a difference. There is a difference. It is related to somehow the date of abandonment.
Okay, okay.
Which date will be considered as abandonment?
Okay. So, how do we distinguish? I mean, you can tell
I
me
need
later.
to explain it on a
Yeah,
very.
you will tell me later.
No, no,
Okay.
no, no. I will explain. I will take time. Don't worry. I need to share screen first.
No, if others are not into it, then it's okay. I don't want to waste others' time.
Teena ma'am, will it be comfortable for you to explain me this part?
I'm sorry, sir.
What is the difference between deemed to be abandoned and deemed to have been abandoned?
Uh, I may not be clear on that. I think I don't have an answer for it.
So, are you comfortable in explaining me to this part?
Mm,
Shall I explain in
yeah,
detail?
please do. Because I'll have to check. I have not gone in depth as to what would to have been abandoned and to deemed to be abandoned. Um, I'm not so certain on that.
See, let us take an example. You filed an application on 1/1 no, Spotty, 21/7/25. You file form 1 with provisional specification.
Okay.
Then by which date I need to file the complete specification?
21/7/26.
21/7/26.
Yes.
But I did not file the
Okay.
complete specification. So it will be considered as deemed to be abandoned.
Okay.
But why it is called deemed to be abandoned? Because when this date will pass now, it is present. This date will be called as the date of abandonment.
Okay.
Now another example. On same date, an FER was issued and you had the time period of 6 months to reply that. But you did not find the reply.
Okay.
It will be called as deemed to have been abandoned.
Is it because we have an extension possible there by filing Form 4?
No, no, no. Even no, you have the possibility of extension, but you have to file the request for that
Oh,
extension
okay.
before expiring these 6 months. You
Yes.
cannot file after 6 months.
Yes.
So it got amended. We haven't filed the reply.
Mm.
But on this date, when the application is got abandoned, this is the present date, but we are taking the past date as a date of abandonment.
Mm.
That is why it is called deemed to have been abandoned.
Okay.
Because on the present date,
Mm.
we are declaring abandonment, but we are considering the date from some past from which it got abandoned.
Mm.
This is the difference.
Okay.
When we are saying deemed to be abandoned, that means we are taking the date of present date.
Okay.
But when we are saying deemed to have been abandoned, we are taking the date from some past on present date.
Mm.
So we have, started our timeline of abandonment from some past date. This is the difference, nothing else.
Okay. Got it.
Hmm.
Okay. Thank you.
And although patent of opponent, when I asked you as a 28, if the patent is granted, it's good. It will be under falling under section 26. Although because section 26 is defined only for post grant, no
Yes.
pre grant.
Okay.
So if we are opposing on the ground of wrongful obtained,
Mm.
that will be the ground, na? So if you are filing opposition is in pre grant and you want your
Yes.
name in replacement of that person,
Mm.
there is no provision specified
Yeah.
how to proceed.
Okay. Okay.
It was my speculation that you will proceed by the section 20. And you said form 6. I was in a hinge. How did you conclude that? Because it's not mentioned anywhere.
Applicant. No, that is for addition of substitution of an applicant.
By the order. Why
Ah.
I had a speculation? Because there is a clause in section 20.
Uh,
You can substitute by the order of law.
uh-huh. Okay.
So by the order of controller, you will be filing form 6 and
Hmm.
your name will be substituted.
Yeah. But that is possible, right?
That is the possibility because
Yeah.
otherwise there is no specified
That
provision
is
for
what.
that.
Okay.
That's
But
why
this
when
will.
you said form 6, now I asked where it is mentioned or have you read anything?
Yeah. So I know I know 26. I mean 20 and 6 are related, but I do have this confusion. See, because sometimes I'm confused. Like in that form 13 also you can amend. Like applicant's name is. Do we amend in
See,
form 13?
now coming to that part,
Oh.
there is a difference between amendment and rectification.
That. Yeah. Yes.
See, amendment is something we do where the rights of any applicant or patentee is not affected.
Hmm.
So in that case, wrongfully obtained, it will not call be as amendment because rights are getting affected.
Hmm.
Rectification is something through which the rights could be affected.
Hmm. Rectification normally means when there is a mistake done, you rectify, right?
But that
Okay.
rectification could affect anybody's right.
Okay. Okay.
Amendment is done where the rights of anybody is not affected.
Okay.
That is the major difference.
Okay. Now, rectification, I didn't get. Is it mentioned as rectification in any of the sections?
Rectification of register.
Oh, register. Okay. Yes, yes. Okay.
That is right. And it can be only done by the High Court.
Hmm.
And
Or
you,
can government do it also? No.
no, only High Court. But when a person's rights may get affected,
Hmm.
and as a person interested, you want to file any request, it will goes under section 78.
Okay.
Clerical error.
Okay. What kind of thing will go as rectification of register then?
Any entry made by mistake,
Okay. Okay. So is
or
it not a clerical error? No.
no, that is not a clerical error.
Okay.
Clerical error, see, there is a very thin line between amendment and the clerical error.
Hmm.
When a mistake is done by you,
Hmm.
it will be corrected by the amendment.
Amendment, yes.
But if the mistake is done by the patent office, it will be corrected by the clerical error provision.
Okay.
There is a thin line. Although whatever will be corrected will be seem to be same. It is like amendment, then what is the difference?
Yeah.
It depends on who committed the mistake in the document.
But then the thing is, even when it is a clerical error, the mistake is from their end. You have to file a form paying the fee, right?
You can be filing, you may not be filing. Even controller on its own may be taking decision to clarify that, correcting that clerical error.
But for that, the form is 13. I'm sorry. Is that the
Yeah.
form 13? Yeah, I'm
Yes.
there.
Only person interested can file request for clerical error, correction of clerical error. Filing form 30, fees 800.
Uh,
30 or 13?
30, 30.
30, no? Yeah.
Yes, Tina ma'am.
also, you said that since it's a clerical error, so I'm assuming, I mean, you said that if the error is being made by the patent office, right? Tell me if I'm wrong there. I mean, if I've got that wrong.
Perfect. Fully said.
So why is it that we also have? I'm forgetting which form it is, but it says opposition when a clerical error is made. I think it's
Form 14.
14. Yes,
There
exactly.
is a provision for opposition.
Right.
Because that is why there is it is made as a separate provision. Because
Huh.
somehow it seems to be like correction of clerical error by the controller, but
Mhm.
in somehow it might getting affected to anybody's right. So that is why before correcting that clerical error, an advertisement will be published.
Huh.
From the date of that publication, any person interested can oppose that correction by filing form 14, and within 3 months from the date of that publication, who thinks that it is not suitable to do. Understood, ma'am? Any confusion?
Okay. No, I'm actually thinking it of from a perspective that what if I only have made a clerical error and I want to correct it?
You
Because
have
you
to
said
file the amendment.
And it's amendment, yes.
form
As an
30.
applicant, if you have done any error, you have
Mm-hmm.
to go through amendment. But if any error is done by the patent office, they will go through
Mm-hmm.
section 78. First, what they will do, they will publish the correction of that error. That we are correcting this error. We have not done yet, but we are proposing this correction. Because according to controller, it seems him to be, it is an error. So if as a person interested, you think that it should not be corrected, although it is correct, it is not an error, you can file an opposition. As the applicant of that application or as a patentee itself, you can file an application, opposition as a person interested.
Okay, I'm forgetting which rule was it for clerical error. I just wanted to read
There is
through it.
no rule, there is only section 78.
Okay, 78. All right. Thank you. Power of controller to correct clerical errors. All right. Okay. The prejudice.
And ma'am, priority date of claims can be amended.
Okay, okay. Yeah, I had a confusion there. How is that done? Like, I'm not.
Through amendment, section
Amendment.
13, form 13.
Okay.
Because
But you have to be,
correct.
you have a threat of, infringing, or, I mean, you have a threat, right? If you are.
No. There could be a situation like, for example, I
Hmm.
have filed a claim in provisional specification.
Yes.
Then when I will be filing complete specification, that claim will be written again in the complete specification.
Yes.
But that claim is having the priority date of the provisional specification.
Yes.
But by some mistake, because I am a patent agent, I did a mistake. I wrote the priority date of that particular claim to be the date of complete specification.
Okay.
So I have to amend my specification now.
Okay.
Okay, to claim that earlier priority date.
Okay.
Discretionary power of controller.
I have to read that. Okay. I didn't read it recently. Yeah.
Discretionary power of controller is something when a controller's decision is having any adverse effect on your application.
Okay.
He will give an opportunity to be heard for hearing at least. That is the discretionary power.
Okay.
See, when we discuss now, if he can refuse or amend your application, that is an adverse effect on your application. So in that case, he will give you an opportunity of hearing. That is the discretionary power, not the civil code powers.
Okay, these are different.
In civil code, it is section 77. Discretionary power, it's section 80.
Okay.
Regarding adjournment of hearing, although you can ask for 2 adjournments collectively, but one adjournment could not be beyond 30 days.
Okay, 1 month time.
And you have to inform at least 3 days prior from the hearing.
Yes, I have heard it. Forgot actually. Yeah. Okay. And there is this 10 days notices for 10 days.
Whenever the hearing is initiated, at least 10 days notice has to be issued before hearing.
Okay.
If you want to desire to be heard, you have to request before 10 days at least. And when a controller is calling you for a hearing, he will inform you 10 days prior.
Okay. And this 3 days is before ending of that 10 day, you should know, isn't it?
Before that.
Okay.
Form 27, although you mentioned very perfectly, but regarding complaint, when a Form 27 is not filed, there is a penalty already defined under the sections of penalties.
Okay.
Section 122.
122. Okay. Yeah. Okay.
And now, according to the new proposed sections, 124A and 124B, you can file complaint under section 122.
Oh, okay.
You don't go for the revocation directly. You can file a complaint under section 122.
Any person?
Yes, any person can file complaint.
122 is for any person, I think. Huh?
No, 124A.
124A, sorry.
Complaint under adjudication of 124A. Any person can file complaint.
Okay. That we are not, like, say I have a patent and I'm not working it. Then anybody can complain that it is not non-working, so revoke it.
No, they won't file you a complaint for revocation. They will file for the complaint of non-filing of Form 27.
Oh, that's it. Okay, non-filing.
They are not here to revoke your application. They will be filing complaint that this person has not filed the Form 27.
Is it? Can it be a ground against infringement also?
No.
Like if somebody has not filed, and no, it cannot be, right? Okay.
And Teena ma'am, I asked you one question regarding complete specification.
Right.
And in complete specification, there are 4 things that needs to be mentioned properly.
Okay. That being?
First one is best method to perform the invention.
Right. Enablement part.
Second part, to disclose the complete information of all your information.
Okay.
In such a manner that it has to be a complete crystal clear. मतलब इसको ऐसे explain करता है act कि a person Indian person with
Hmm.
a reasonable skill, with the average reasonable skill, should be able to understand your application, your invention.
Correct.
Okay? And defining the complete scope of the invention.
Mm-hmm.
And after that, it should be accompanied by an abstract.
Right.
These four parts that needs to be keep in mind while drafting a specification.
And I think claims were missed also, no? Claims are important part of it.
That will cover under the scope of the
Scope
invention.
of the
Okay, description part, okay.
And if you are taking notes now, take a note of section 99 to 103 of Patent Act, 106 and 113. These 6 sections are of Patent Act which are directly enforced in Design Act as well.
Yeah, yes, government invention. Okay.
Groundless threats, uh, validity of certificate,
Yes.
certificate of validity, what I am saying.
Hmm.
And under section 20, 99 to 103 as well.
Hmm.
Section 20 of Design Act,
Hmm.
designed to bind government. It will be as per the section 99 to 103 of Patent Act.
You had asked me on that inventor part, right? Did I do justice? I don't know. I was a little confused because
I
like
was asking in the context of applicant, not
applicant, not
inventor.
inventor. Okay. I first thought it's an inventor.
Although you mentioned proper, I think it's good to go. For you, ma'am, I will advise keep on revising the act at least.
Yes.
And you need 40 marks. I think you may get the 40 marks.
I hope so.
You may get the 40 marks because people like you technically sound with a good network and could be a great impact on this domain. They want you to be a patent agent, so they will be asking you much more questions.
Okay.
And keep in mind that if they are asking much more questions, now don't be afraid of that.
Hmm.
They are asking because they are willing to give you marks.
Okay.
So
Yeah.
they are probing you.
Hmm.
So if you are asking more questions, be happy about that.
Yes. And I think I need to revise more on universities, how, educational institutions are benefited, the
Policies.
policies, the schemes,
Hmm.
Kapila, and all those things. I think I need
Particularly the WISE policy, which is particularly for female candidates.
DSP wise. They have stopped that Kiran scheme right now. Now it is not working. But there are
But
other
other
provisions.
possible schemes under WISE category, na?
Yeah, and even IP portfolio, like education institutions, do have some advantages, right?
Hmm.
Like, and even there are. I think that those things I need to maybe IPR policy and stuff.
Definitely, ma'am. IPR
Mm,
policies, recent trends, and there's special provisions for female athletes.
yeah, women applicant. That is expedited examination. And apart from that, there is nothing much, no.
Not in directly to the act, but through the different policies at least.
Mm-hmm. And chemistry related, I think 3D and 3, although that'll be mostly on
Ma'am,
that.
they might ask you case law.
Mm.
Have you gone through any case law? Have you heard
Okay.
any case?
Okay.
That is, और मैम देखिए
You know
क्या
what?
होता है
Actually, I wanted to tell you my invention, my application for
project.
my doctoral work is on uranium. I have done work on uranium, okay, like uranium remediation. So my materials are being used for uranium remediation, which is directly related to, I mean, indirectly related to this, Shanti bill and stuff.
Ma'am definitely tried to encounter with that.
Yeah. So
Mention
because
that part.
that is what I wanted to do because I can
Uh,
explain that way.
mention that part that my project
Mm.
was related to uranium. They will
Mm.
definitely asking you a
Yeah,
Shanti bill.
because whenever I went for any interview, the moment I mention uranium, people have interest in that.
Ah.
So,
So definitely because
but
they would love to introduce, have a conversation regarding Shanti bill.
section, yeah.
And there could be a few questions like psychological or philosophical questions. Although I haven't asked you till now, but definitely will in next session as well. What philosophical like what is the what will be the impact of introducing the Shanti bill?
Okay.
है ना? These are something which don't have any scope. You can answer anything
Yes,
that
yes.
comes to your mind and being feel suitable.
Yes.
So there is a possibility this time I am speculating they will be asking more philosophical questions rather than the direct question from the act. But when we will be answering those philosophical questions now, try to connect the part with the act at least using
Yes.
sections. Try to
Yes.
impact with the sections. They might come back to asking question from the act or the already proven section, because these philosophical questions don't have any particular answer, no
Yes.
defined scope, it could be anything.
Yes. And like you mentioned, recent things which we need to update on, right? CRI guidelines. No. So I am just thinking whether SCPs and all, so much in detail, they may not be asking if I'm not from that technical background. Is that so, or will we go
No,
in detail?
they might ask you, is SCP is only restricted to telecom industry?
No. Okay. Yeah. Such things.
It
Okay.
could be it could be related to any industry, no?
Yes. Yes.
Then
Yes.
what are the SCPs related to chemical industry or the chemistry?
Oh, yes. That I may have to check.
You know?
Okay. Hmm.
They might ask you the SCPs related to your domain.
Okay, that way we need to prepare. Okay, and AI is another area because see they can ask you because what I presume is even the patent agent job to some extent patent search everything is now made easy using AI, and there is a kind of a threat also like people are drafting using AI tools. So can
They
they come
might
up with
lose their
such a
invention
question?
somehow.
Yeah, they like they can ask you like now that you have AI tools, which AI tools are used or in drafting, in searching.
No, no, don't mention AI tools in drafting.
That and that's what you are not supposed to use. So if they trick you
Ah,
asking such things, no, like
don't if they provoke you to use
mm,
AI, है ना?
mm,
Directly mentions that AI cannot do the legal
yes, yes,
documentation. They
that,
cannot draft
mm.
properly. So I don't think AI will be
So
used
what is
wise
the
decision.
role of AI in patent field? Like how significant is the developments in artificial intelligence in patenting? So can
It
we
can
expect
help you
kind of
to
questions?
understand better invention.
Yeah, we can
We can
understand.
use that tool to understand the invention better
Mm,
or to compare,
mm,
है ना? But you cannot use to draft legal document.
And while searching, maybe we can get the statistical data about the prior art, what is available. Some of the tools make it easy now, no? You can
For
access
that,
them.
you have to go through the databases, not
Yeah.
AI.
So, okay.
Not AI. मैम AI को मत लाइए कोशिश मत करो.
No, I'm
अगर वो
saying
ले आए, अगर
because
they
if they
try to
ask
bring,
me,
हाँ,
yeah, because
then
nowadays everybody is talking about AI, right? So I'm just thinking if they ask a question.
even I came across some recent wordings of Supreme Court.
Hmm.
They are worried about the new lawyers in the market who are using AI to draft
Yes, yes,
petition in
yeah, yeah.
Supreme
There
Court.
was a discussion. Yes, yeah.
So it is
And
a
the other
controversial
day,
topic.
some people who attended this AI conference, no, so they expo they in the patent field they have discussed about Saral AI.
Mhm.
They had attended a conference on that and all that. So I just follow these posts, recent posts. So I was thinking, will they be? If they ask, we have to be safely. We have to tell that answer, right?
It could be like, we are not at a negative
Ah,
side.
we should be using it also to some extent.
But in not, we can paraphrase our answer like, if we develop a AI
Hmm.
particularly for the legal domain,
Yes.
then I think that will be wise to use that particular
Hmm.
AI, but not a general domain AI, because AI is not trained with a thinking mindset. It
Yes.
cannot think on its own.
Yes. And maybe I can see from my personal experience of teaching, I have plenty of examples. Like, you give an assignment to a student, they just put it in ChatGPT, get the answer, but many a times it's not right. So you cannot compete.
Definitely, at least, definitely not in the domain of mathematics.
Yes, that's what numericals, especially when you give that's not grown up to that level that everything is foolproof.
So if India develops an AI in future, particularly for the legal domain to help the judiciary to work more efficiently, then I think we can look towards AI to draft our legal documents, but not before that.
Yes, yes.
Because as a patent agent, we need to welcome new technological advancement with our open arms. We cannot restrict कि नहीं AI का use नहीं
Yes.
होना चाहिए, है ना? We are displaying that we have some restrictive minds towards a technological development. We cannot show that.
Yeah, we
Being
have.
a patent agent, we have to
Yes.
praise that part. But in such a manner, everything got justified.
Yes.
I have an example here if
Yes.
Dhanaji, if you would want to use it. So very recently, eSpaceNet has actually introduced the AI feature in terms of searching classifications. Because sometimes when you're doing patent searches, you have to identify, the first part is to actually identify the classification under which your patent subject matter will fall. So what they've done is to at least give you a head start. It won't give you the exact classification as to under which your patent might fall, but at least it'll give you a head start as to which particular classifications you can look up. So maybe AI might help us only on very specific and restrictive aspects, but drafting definitely not, because a draft needs to go in a strategical manner. Plus, in the sense that, see, ultimately it's impacting the psychology of the reader. It needs to go in a particular chronology as such. So, be it any kind of drafting, be it any legal document or a patent draft for that matter, I think it's better to restrict it to only our own intellect, but not that of the AI.
Yes.
That is the reason, major concern that Supreme Court is concerning the use of AI.
Exactly. Yes.
We can use it as an assistant, like to assist in certain things.
Absolutely. Even I remember I actually was doing a prior art search very recently. Also, it was from a mechanical domain. It was difficult for me to ascertain as to which particular classification would that matter fall in, even though it was nothing to do with the Indian jurisdiction as such. But AI did give me a head start as to which particular
Class it could be.
group I need to look into. So, I mean, it's just a good facilitator as to how you can go about it, just to give you a hint, maybe, but the rest of it obviously needs to come from a human brain.
That is. That's why AI, the development of AI is not that up to the mark that it may replace the human brain till now.
Funnily,
It-
if you have gone through the CRI guidelines where it talks about who will be the inventor in case of an AI,
Yeah.
very pretty. It's it might seem that it's placed so plainly, but come on, I mean, think about it. An AI can never be an inventor.
That's
They are
why
only working
they
based on the information that's available on the website, not as to what I can create from my intellect.
that's why they mentioned the person who developed that AI will be the inventor of that invention.
Right, right.
So it's just like closing the door before debating.
Hmm, hmm, hmm.
They have just concluded in such a simple manner that a person who developed that AI will be the owner of that invention. How could it be? Because if I am the one who is giving all the information to the AI and
Correct.
all that data that providing the AI to come up to that invention, how could the person who developed that AI will be the owner of that invention? That is a totally debatable point.
Right.
Although we need to avoid these kind of topics, but still, and coming towards your body language, it was good, ma'am. It seems to be like an experienced person, you know.
Thank you.
Uh, anything you want to ask? Because from my side, I think it's good. Although we will have another session as well
Yeah.
before
Just one
Wednesday.
thing I remembered now. I just came across a case of a Japanese. They filed for I think nematoda was used for cancer treatment. I mean, they found that they studied urine samples of cancer patients and interaction of nematoda, that's a worm, that with the sample was actually they could distinguish between the whether the patient has cancer or not by that study. Okay, and they filed a patent in India, and it was not granted because they mentioned it as
3I.
treatment, three
Three
eye.
I.
They
I think it was
mentioned,
Method of
last.
treatment is not
yeah,
patentable in
method
India.
of treatment. But the thing is, interesting part is if they could have claimed it as a chemical interaction between those things, then there was a chance that they could
Hmm.
get
They
that.
would have
The
introduced that
interpretation
invention as a
between,
process.
yeah, a process between of
Hmm.
biological interactions.
That could have been patented.
Okay.
But now even they have locked that part also. Now they cannot claim in another way.
Mm. And
Hmm.
I came across the Swiss type of claims. No, Swiss type claims. Are they allowed in India? Swiss
No, that's
type claims?
application-based claim. US claims.
Purpose
They're not
limiting
allowed.
claims. No.
They're
So
not
they
allowed.
are,
It's only allowed in the US and certain parts of, not completely in the US, but in EP they allow. In China to a certain extent, but again, not as much.
okay.
They're very restrictive about it. In India, they don't. They just don't. It's a blanket bar.
Oh, really? Okay. And since you're a lawyer, that's helpful. Okay. So
No,
because
actually,
mentioning that, it,
constitution matters. So that's
mentioning that it is allowed partially or something they mentioned. So I'm good.
why.
Yes.
No, I think what you're talking about is the kit claim, I believe.
No, see, my question was not that. The question is there is a drug which is useful for one particular disease, non-drug. If it
Hmm.
has another, if it is now found that it is also, can also be used for another,
Hmm.
treating another disease, can this drug be patented? Something like that.
That
Yeah,
is
I'm
the
sorry.
scope of 3D, new
So,
use.
New use.
yeah,
Yeah.
So you cannot patent that drug on the basis of new use that you identified.
even if it has a therapeutic efficiency enhanced.
No, therapeutic efficacy will be compared on the basis of the earlier filed therapeutic efficacy.
Okay.
But the drug is same, na?
Mm.
The drug is same. If that drug is same, it will be rejected on the basis of new use.
New use.
Mm.
But if you have modified that drug
Mm.
and the efficacy has been improvised,
Mm.
that is patentable.
Mm. And so it won't. Will it come under the claims? Won't it come under purpose limited claims?
Purposely,
Because this is for a I mean, because you are claiming only for that purpose.
it is not patentable.
Okay.
It's not a matter that that kind of claim is allowed in India or not. It is a matter, is
Of
it
3D.
patentable or not?
Okay. Okay. Okay.
It will fall under that category. You
Okay.
cannot just define new
So
purpose as a
some of
patent.
these things, no, you don't get an answer anywhere. Like, it's not specifically mentioned or anything, no. So you have to
Ma'am,
guess, or
ma'am,
and you.
in these type of questions, now,
Mm.
if they are asking further more questions, just say, sir, I don't know. I'm not able
Yeah.
to identify what should be
Yeah.
the appropriate answer.
Mm.
So simply said, I'm not able to answer. Don't fall in the deep.
Because even I don't have that kind of experience working with these things also. So,
Ma'am, it's not about
um,
experience actually.
yeah.
Although you do have experience,
Mm.
but when they are asking you questions related to one topic only,
Mm, mm, mm.
and try to answer initially one
Yeah.
question, two question.
Yes.
But if they are going beyond, they are
Yes.
not leaving the same topic, asking you
Mm,
anything further, not asking.
mm.
Simply say, sir, I am not able to answer in
Yeah.
that much depth of the topic.
Mm, mm.
Okay.
And present yourself as a beginner, as a fresher in this
Yes.
domain at least.
Yes. Yes.
Mhm.
Although I am an expert in chemistry, having experience of 15 years,
Mm,
but I am just an infant baby in this
mm.
domain.
Yeah, true.
Right.
I have.
Present yourself as that kind of
Yeah.
a person.
Yes.
Okay.
Okay.
That should be your, secret
Sure.
mantra in mind.
Mm. Yes.
Don't go depth. They will
Mm.
be eventually asking you if they seems to be you keep on answering the questions now.
Yeah.
They will be asking further questions. So
Mm.
keep a halt.
Mm.
है ना? That in that way you will be able to escape that
Yeah.
Basically, we don't have to lead them on to asking us more questions attached to.
Simply say, sir, I am not able to answer that much depth.
Okay.
Although I am not able to recall or I haven't read in that much depth.
Okay.
You can simply say that.
Yes.
But it need another way that you can, get out of that trap. Although that needs a practice, but if you able to connect your answer to some other provisions,
Yes.
in that way you may got also out of that trap, because they will be eventually asking you the question from the mentioned provision that you related to another topic. So they will be moving towards another provision, but framing the answer in such a manner needs practice,
Okay.
and you cannot predict what kind of questions they
Yes.
will be asking. So
Yeah.
that
I
is
mean, true.
not practicably possibly to
Many
do.
things we'll have to do then and there also, like according to our own, understanding and all,
Hmm.
because it's in.
And one more thing, ma'am, I
Yes.
will personally, I'll recommend for you at least. What is your timing, matlab, in second half or first half?
First half, 10th, I mean, according to that list, I'm 10 in number.
In first half.
9:32. It should get over by 1:30 according to the schedule. So I'm the 10th person.
So that means you will be entering, if they are asking 30. So that means you will be entering in almost the last of that part,
The
around 12:30 or 1, around 1.
maybe. Yeah.
So in that scenario, na, ma'am, they might be in a rush to leave. And they might don't ask you so much questions to justify your 40 marks.
That
See,
is a trouble.
make a note of it. You
Okay.
have to say one statement. Sir, to qualify this examination, I need 40 plus marks. And to justify this 40 plus marks, you want to ask me any further questions, please do, sir. Definitely say this statement.
Oh, is it? That's not an issue.
No in an issue. They will definitely give you marks. And but although, ma'am, please
I know.
let me mention, it is kind of a double-edged sword.
That is what. See,
Because
because you have
if
three
you,
panelists, not all will be having the same idea also.
that is not an issue. But if they ask you questions and you are not able to
You should
answer,
be able to answer. Yeah.
then they might deduct you further more marks. But
मतलब
if
पूछ
you
के
able,
वो हमने ही पूछा और आंसर
खुद का
दिया।
गड्ढा खोदा और उसी में खुद को गिरा लिया,
वही
तो
वही।
अगर आप आंसर दे पाए, definitely I guarantee they will give you 40 plus. But if you don't answer, अगर वो 30 भी दे रहे होंगे तो 10 मार्क्स और काट लेंगे.
सही।
But why I am suggesting this? Getting failed without asking is better to fail after asking. है ना?
If it goes for one good 10-15 minutes, that's good enough, I think. No?
हाँ, नहीं, if they have asked enough questions, like 8 to 10 questions, then it's good enough.
Yeah.
If there is a chance they ask you just 1 or 2 questions and ask you to leave the room, then definitely say this. Because it happened last year with one of my candidate. Although he was a scholar one, scored around 83 in paper 1, 78 in paper 2.
Still didn't go.
But when he entered in the Viva, he was asked only one question. And he was like, what is this? So we were prepared with this part. Directly say, sir, I want these numbers.
Okay.
And to justify this, if you want to ask me anything, please do. And they asked him 3 questions. He answered those and he got 47 in the Viva.
Very good. Okay.
So that is kind of that bluff that we can play. That is some trick that we need to use.
Oh, that's good that you reminded, because I would have never done that otherwise.
So I am recommending this trick who needs 40 plus. Not for Teena ma'am you just need, I think, 33. So you don't need to use that. They will definitely be giving you these marks. Because it seems to be like that they used to give at least 30 marks.
Okay.
Because to qualify this examination, you need 60%.
Right.
So they will be giving you at least 60% of Viva at least. So the remaining part is still in your hands.
Right.
So justify those, they will be giving you at least 30 marks. And if you get a better answer, and what I am speculating, you will getting 35 plus Teena. in Viva.
All right.
But for you, you need to go with that part.
But I think I'll need some help with more hypothetical questions and more critically, because there are certain provisions, especially when it comes to licenses. I'm kind of weak there. I would love for you to drill me on that part, because I understand, there are certain basic requirements that they are looking for, but besides that, there are certain procedural aspects, like for example, the introduction of rule 138. Now, if I'm to file an FER response, I do have 6 plus 3, but when will the extra 6 months be counted from the 6
Okay.
plus 3 plus 6, or will it be 6 plus 6? You're getting what I'm trying to say?
It could be 6 plus 6. It could be 6 plus 3 plus 6 as
Plus
well.
6. You're understanding where I'm coming from,
Yes,
because
I am
again,
understanding.
137 also, it talks about petition, but in what scenarios? Because even though I've excluded certain provisions, but
We can have a
138.
discussion. We can have a definitely a
Hmm,
discussion on this, how the
right,
138 will be implemented, and what will be the impact of 137 on that.
right.
And
There are, you remember in 2025, there was a question where they had asked specifically in the last section of the MCQs paper 1, उसमें ये था कि कौन से deadlines are given in the rules and which deadlines are given in the section.
that
Now,
is directly because of the rule 138.
exactly, right. Now, if I look at it, the language of 138 simply says that notwithstanding anything contained in these rules, it nowhere says
That
that.
is the major crux.
Right. Now, if I say that I have to file a complete specification after provisional, now the 12-month deadline is given in the section. It is not given in the rules.
You cannot apply 138 on that part.
You're getting what I'm trying to say. So I think I'd love to
I do
have
understand, ma'am. I do
this.
understand.
Yeah.
That is the major hidden X factor of 138.
Right, right.
138 is only applicable on those timelines
Mm-hmm.
which are mentioned in rules, not in
Hmm.
the act.
Not in the act.
Like there are several timelines mentioned in the act. Let us take an example. So
Mm-hmm.
12 months for the provisional after complete after provisional,
Mm-hmm.
the timeline of 18 months for the restoration,
Yes.
the 12 month period in section 31 and 32,
Uh,
and the 3 years of compulsory license,
uh-huh.
2 years of compulsory license after granting and the revocation of patent,
Right.
and 6 week timeline for the FFL.
Okay. Right, exactly. Mm-hmm. Correct,
So
correct.
these are some of the timelines which are mentioned in Act.
Act. Hmm.
So the 138 is not applicable on those sections, those timelines.
Okay.
Like the timeline mentioned in the response of FER, you have 6 months.
Hmm.
And you forgot to mention the extension. You want to ask for the extension. In that scenario, you can ask for the 138.
But
Timeline for filing request of examination of 31 months. You
yes.
can apply 138 on that
What
part.
about national phase entry?
In that part also, national phase entry
Okay.
and request for examination is also 31 months. No?
Huh.
In that part also, you can apply 138.
Okay.
Timeline for Form 27.
Yes, that I know. That I know.
That although that also have a separate document identifying that.
FAQ.
Ah.
You're talking about the FAQ, right?
Yes, yes, yes.
Okay.
Particular, there is a document for explaining the timeline for Form
Exactly. Yes.
27.
Yes.
Timeline for filing of renewal fee as well.
Okay. That's in the rule, right?
So whatever is mentioned in rule
Can
can
you explain me?
use by the 138.
Okay.
That is why, because you are from legal background, you were able to understand the legal language, why it is such that nothing is contained in under this rule. So, but most of the people who are preparing for this examination are not from a legal background, so they don't understand the language of bare act or the rules. That is the major issue in this part. Because
Okay.
initially when I started for this, I was also not able to understand this legal language. But Over the period of time, I used to have a habit of reading Bare Act itself.
Right.
Then I understood what is this mean, what is this mean. Even though still today, when I go through the Patent Act, it never ceases to amaze me. Every time when I dive into that, grab something new.
Absolutely.
Patent Act
Happens with
is
everyone, I believe.
Patent Act is very beautifully designed act, I would rather say.
True, true.
Iyengar sir did a very good job.
Yes.
Not good, but the great job, I would rather say.
Will we be asking then, and since we are talking about that, is there any improvement that or any suggestions on the act that you have?
No,
If
no,
will they
no,
ask anything like that? Because
no.
some people said they could ask on such things like, what do you think? Could be
No,
one.
no, no. We don't have to say any
We don't have that expertise to
negative.
tell that also, right?
No,
No.
but one must never do that, especially.
Not to do that, ma'am. यहाँ
That's
पे ये
what
काम नहीं करना है.
they
Very,
get offended like anything.
हाँ.
yeah,
For
that's
us, Patent Act is perfect.
Right.
We have to be act like their friend. We cannot say that you have done this wrong and correct it. So we don't need to do that. Although we have some suggestions, but keep it with you till you
because
become a
your
patent agent.
suggestions may not be agreeable to them. So even
If you have suggestions, go in the video conferencing. Open a video conferencing, not here.
Not
yes,
yet.
Go there
yeah.
True.
with the anonymous identity.
Yes. Yes.
Okay. So I think if any few questions that we can have, otherwise we can wind up the session.
Yeah, I think
I
it's.
think
But the last thing that I want to mention, have you checked your mail ID? I gave you the access of the early recordings.
yes.
I checked. Yeah, I got it.
Go through those recordings, and you will have some few insights other than this that we have discussed.
Okay.
Okay? So that
Well, this
could
is
be a part of training as well.
okay. This
Those
is
are
very.
the recording of mock vivas, ma'am, actually,
Oh, okay, okay,
with the other candidates.
okay.
Okay, till now, I will call you separately to schedule your vivas.
Sure.
Okay.
Okay, thank you so much. I actually wanted to tell you this that you're doing such a great job, okay? And really, because I've come across a few people who are doing this kind of, I don't know whether it is going on record or will it be fine,
So should I
but then,
stop recording?
no, I'm not blaming anybody, but there are people who really charge extraordinarily for coaching and all that, for Patents Act. Of course, people who want to go only will go, but then I am surprised like how you are doing it with so much of enthusiasm, and that's commendable.
Ma'am, internally, if I would rather say, I am maybe teaching patent act, but from my internal habit of the soul, I am totally a teacher and I love
I
teaching.
know that is so obvious. That's what I'm saying. It's very
And
obvious.
although we have a separate batches all for
Hmm.
the complete act people
Yeah,
who
you
are
could
running
have.
from last 6 to 7 months.
Okay, okay.
And I came to across some incident where motivated me for this to have a separate session for the people who are, although not the part of that batch, but still seeking some, help in for preparation of vivas. That's why I took this initiative and thought to have a very reasonable amount so that everybody could pay.
Yeah, I was.
And
I
I
think
really
we're
was.
rather quite fortunate to even
Hmm,
stumble upon your post in the first place because,
that is true.
like you said, it's very rare of somebody, aside of their set course line, that they would give a separate time, at least make out 2 hours
Hmm.
out of their busy schedule to simply mentor. Right? I mean, that takes a lot of effort.
ma'am, I will take everything as a compliment until and unless everybody who's having contact in with me be able to qualify this examination. Whenever I start with a candidate, I start with this commitment only. I
Right.
will be holding your hand till you qualify the examination, but
Mm.
it could be any reason
Yeah.
because of non-qualification. But till you qualify, I won't leave you alone.
Mhm.
So that is the only commitment. Although, to fulfill my needs of bread and butter, I need to charge a little bit amount.
No,
That
but
is
that's very reasonable. I mean, more than reasonable is what I feel for the work you're doing. That's why I am surprised because we live in a world. No, we know how it is, and there is no harm in charging also. Like for the skill and for your knowledge and for your effort, you have to be no definitely.
Ma'am, just to maintain this setup, what I'm
Mm.
using, the gadgets, the Wi-Fi, the Zoom,
Yes.
because
Yeah.
everything is paid now. So
Yes.
just to maintain this setup, I need to charge that amount. Otherwise, if I would have get everything in FINA, I'm able, willing
No,
to
that's not
provide the services
needed.
in
Yeah. Okay.
that is a part. But
Thanks a lot.
let's see what is the impact. I just
Because
want
it's
everybody
giving a
to
lot of
qualify this.
clarity because I didn't want to go for coaching because I thought a lot of studying for so many years. I didn't want to spend, as it frankly, I didn't want to spend any more on studies and stuff. I wanted to do on my own.
But
So
you did a great job, ma'am. On your own as well, you did a great job because the answer that you put was not expected. The most part when I felt amazed when you mentioned Form 6 because
mm,
I haven't have any proof to justify that theory. That
mhm.
is just a theory that if in pre-grant you may file Form 6. That's why I got amazed. Have you read anywhere in this part? I want to go through that document
And
again.
it only it's
So even you did on your own, you did a marvelous job.
I did such stupid mistakes in my paper one, a few questions I knew and I didn't read it properly. And being a teacher, I felt so ashamed when I came out like not and all I missed.
That's why
And
I used to say that a student will always be a student.
Yes,
Doesn't
that's
matter which age is of.
true, really.
true.
That
Very
was
true.
shocking.
Student still be a student. Even do I as a when sitting in any class like a student, I
Hmm.
would rather do some mistake
That's
that kind of.
very big blunders and it should not be costly for me is what I'm thinking now.
So that's just a reminder. You are
Mm.
a student, not a teacher here.
Yeah, yes, yes. Yeah.
So that's
So
just a
nice
reminder.
interacting with you both. Okay, thank you so much.
Pleasure is all mine. Thank you so much. We will have another session as well. And although you will be provided recordings of each and every one, so go through
Okay.
those. You have the recordings access you with you. Remember the email ID that you shared while registering. Uh, you have to log in YouTube through that email ID.
Okay.
Okay.
If you want access to any other email ID, just ping me. I'll give the access. But for that access, you have to log in through YouTube to that same email ID. Otherwise, you won't be able to access those recordings.
Okay.
Okay.
So keep
Okay.
learning, keep revising.
Yeah.
Still the Viva. Okay.
Thank you.
That's it.
Thank
Okay. Thank you. Have a nice day. Thank you.
Thank you. You too have.